Welcome to another episode of Truth Media TV. And in this episode, I will be talking about the controversial topic of abortion, which has been pushed in the limelight right now with the overturn of Roe v. Wade in the United States of America. Roe v. Wade is believed to be the ruling that gave women in the U.S. a right to abortion. So let's take a look at this case and see what it is all about. Now, Roe v. Wade was the landmark 1973 U.S. Supreme Court ruling decision that created a constitutional right to abortion in the United States. From here on out, I'll be referring to the Supreme Court of the United States as SCOTUS. So, SCOTUS held that a woman had an absolute right to abortion during the first trimester of pregnancy. The court decided that a set of Texas laws that restricted women from having an abortion in a majority of cases violated a woman's constitutional right to privacy. Caveat 1. In the US, there is no clear constitutional guarantee of privacy. In Einstead versus Bird, 1972, the Supreme Court claimed to have discovered the right to privacy in what it called, quote, penumbras formed by emanation, end quote, from other fundamental protections, particularly the due process provision of the 14th Amendment's liberty guarantee was deemed to have an implicit right to privacy. The due process clause states that, nor shall any state deprive any person of life, liberty, or property without due process of law. Caveat 2. The right to abortion was never included in the US Constitution. What actually happened was that the Roe v. Wade ruling claimed that there was an implicit right to privacy. This right to privacy was also not explicitly stated in the Constitution, but it was invoked by penumbras formed by emanations. The implicit right to privacy was then interpreted to include abortion. From then on, women wrongly believed that the Constitution originally gave them a right to abortion. The term penumbras formed by emanation means that a right was created by an implied powers of the rule. So who were Roe and Wade? Actually, Jane Roe was a made-up name that the court used to protect the identity of the plaintiff, Norma McCorvey, who sought an abortion in Texas in 1969. She was 22 years old at the time, single, jobless, and pregnant with her third child. Henry Wade was the district attorney of Dallas County, Texas, who McCorvey sued when she tried to get an abortion but was unable to do so because it was illegal in Texas. Texas law at the time made it illegal for a woman to have an abortion except when it was necessary to save her life. Let's look at the legal arguments. SCOTUS decided two important things in Roe v. Wade. One, the United States Constitution provides a fundamental right to privacy that guarantees a person's right to choose whether or not to get an abortion. Two, however, the right to abortion is not absolute. It must be balanced against the government's interest in protecting the health and lives of unborn babies. The state of Texas made two primary arguments in defense of the abortion law. One, states have an interest in protecting public health, medical standards, and fetal life. Two, furthermore, the 14th Amendment protects a fetus as a person. And 3, states have a compelling interest in safeguarding the lives of unborn babies from the moment they were conceived to the moment of birth. Jane Roe and others made the following arguments in support of their claim of an absolute right to privacy. 1. Texas law violated an individual's 14th Amendment right to privacy. 2. Texas law violated the Bill of Rights guarantee of marital, familial, and sexual privacy. And 3. The right to abortion is absolute. A person has a right to terminate a pregnancy at any time, for any reason, and in any way they choose. Let us look at the Supreme Court's decision in Roe v. Wade. SCOTUS divided the two arguments presented in the case. First, the court acknowledged that the right to privacy does apply to abortion. Everyone has a fundamental right to privacy as stated in the Due Process Clause of the 14th Amendment. However, the Due Process Clause makes no explicit mention of the right to privacy. But SCOTUS has recognized such a right since 1891. Just 1 year before Roe, SCOTUS stated that, quote, under a constitution of free people, there can be no dispute that the concept of liberty must be broad indeed, end quote. In Roe v. Wade, SCOTUS determined that this right to privacy includes the ability to control pregnancy. The justices recognize that when one is forced to continue with a pregnancy, many things are at stake, including one's physical and mental health, financial situation, and reputation. The state's argument that constitutional protections begins at conception was rejected by the court. The term person is not defined in the Constitution. It does, however, state that U.S. citizens, quote, born or naturalized, end quote, in the U.S. are protected by the country's legal system. After reviewing previous rulings on unborn children, the court concluded that, quote, the unborn have never been recognized in the law as individual in the full sense of the term, end quote. The Roe v. Wade decision takes into account various perspectives on the beginning of life. Many Jewish people, for example, believe that life begins at birth. However, it is broadly accepted in the Catholic religion that life begins at conception. Although doctors hold a variety of views, they all tend to agree that life begins before birth. The court, on the other hand, determined that it is not up to the state to decide when life begins. Quote, we do not accept that by choosing one theory of life, Texas may override the rights of the pregnant woman that are in question, end quote. Nevertheless, as previously stated, SCOTUS decided that states can place some restrictions on abortion because the right to privacy is not absolute. Furthermore, it established a framework that balanced the rights to privacy with the objectives of the state. The Supreme Court created a framework for weighing state interests with privacy rights. The court separated pregnancy into 3 12-week trimesters to define each party's rights, since it was recognized that pregnant women's rights can conflict with the state's entitlement to protect potential human life. The ruling of SCOTUS were as follows. 1. A state cannot stop a woman from getting an abortion during the first trimester of pregnancy. It can only mandate that the abortion is done by a licensed physician under circumstances that are medically safe. 2. A state may regulate abortions during the second trimester if the regulations are logically connected to the health of the expectant mother. And 3. The state's interest in preserving potential human life takes precedence over the right to privacy during the third trimester. Therefore, the state may stop a woman from doing an abortion unless it is absolutely necessary to protect the pregnant woman's life. Many people believe that the Roe v. Wade decision made abortion legal. However, this is not entirely correct. It had an impact on how states could control abortion and confirmed that it fell under a person's constitutionally protected right to privacy. The Supreme Court justices agreed with Roe that abortion was strictly a private matter, and since abortion was a private matter, the Constitution prohibits government from meddling in private matters. The state of Texas, on the other hand, responded that there was no justification for a right to abortion in the Constitution and that states had regulated abortion through common law offenses or statutory crime. Therefore, claiming that, the 14th Amendment provided any kind of protection against abortion restrictions was irresponsible. The issue at hand was the state's duty to protect those who cannot protect themselves. Caveat 3. The decision in Roe v. Wade appears to have been written with the intention of inflaming the abortion debate. Let us put things into perspective. SCOTUS completely invented the right to privacy, which then became the absolute foundation of modern abortion jurisprudence. In fact, there are no references to privacy that have anything to do with contraception or other public moral laws of that sort. Furthermore, Roe did not describe substantive due process, but instead simply invoked it. The underlying doctrine provided prenumbers formed by emanation from the 14th and 15th Amendments, and these prenumbers created implicitly the right to privacy. The 15th Amendment governs the federal government, while the 14th Amendment governs the states. The 14th Amendment states that no state shall deprive any person of his or her life, liberty, or property without due process. In essence, substantive due process means that there are some rights that are absolute and cannot be arbitrarily taken away by the state without running afoul of the due process clause. The text of the Constitution clearly states that locational privacy is protected. However, there's a concept known as decisional privacy, which is the right to make decisions without the government directing the outcome of the decision-making process. Then there is the right to act on that decision, regardless of whether the community believes that that action is contrary to the public good or what is known as state interests. Do women have a right to privacy the way that it is applied to abortion? Roe claimed that they were not making decisions regarding the value of life before birth, but that is exactly what they did. So let us examine the pro-life versus pro-choice debate. There are two fundamental principles that are competing with each other. We must define pro-life and pro-choice in order to understand the heated debate that has divided society since the 1970s. The meaning of the terms is typically applied in the context of one's own personal beliefs. However, I will attempt to define each term as objectively as I can. So let us look at pro-life. Pro-life is a fundamental belief in the value of human life. It is the belief that every human life is sacred and should be protected regardless of size, level of development, education, or dependency, and that aborting an unborn child is a violation of this fundamental right to life. Pro-choice, on the other hand, is a fundamental belief in bodily autonomy. It is the belief that every woman should have control over her own body and life, and that denying a woman an abortion is denying her the right to bodily autonomy. There are several arguments in favor of both sides of this issue, but before we can have a discussion, we must answer one fundamental question. When does life begin for a human being? There is no clear consensus on when life actually begins for a human being, and in my opinion, the exact moment that life begins is not relevant to the discussion. What am I talking about? Well, this is because the right to life is not absolute when it comes to the other. What do I mean by that? A person has the right to prioritize protecting his or her own life over the lives of others. This is what we call self-preservation. For instance, a person may take the life of another person if it is absolutely necessary to protect and preserve his own life. A person effectively forfeits his right to life when he seeks to take the life of another. As a result, it is now up to the other person to decide whether to protect their own life or the life of the would-be murderer. The point is that abortion must remain an option for pregnant women, but it creates some dilemma. A woman has an absolute right to protect her own life when it is absolutely necessary to do so, regardless of who or what threatens her life. But an unborn baby has an absolute right of protection under the law as well. Pro-lifers argue that life begins at conception and frequently invoke their religious beliefs to support their position. However, God and religious dogmas are not relevant to the discussion because the Constitution guarantees religious freedom. Pro-choicers argue that it is impossible to know when human life begins and that science cannot provide an answer to this metaphysical question. But if we agree that we don't know when life begins, then the argument must fail because the benefit of the doubt should go towards preserving life, right? We must look to gestation for the answer to the question of when life begins to provide a window of opportunity for a woman to terminate an unwanted pregnancy. The law should be able to defend a developing fetus as a sovereign human being as soon as you can start to recognize its body parts. It is generally accepted that the baby's eyes, limbs, and heart can all be seen on an ultrasound scan 4 weeks after conception. Therefore, abortion of unwanted pregnancies should only be performed within those 4 weeks. Let us look at some of the issues that people keep fighting about. Issue number 1. Abortion laws violate a person's right to bodily autonomy and have far-reaching consequences. Pro-choicers contend that every woman should have control over her own body and that taking away the freedom for women to choose whether or not to have children will have serious negative impacts on the economy and set women back decades. However, pro-lifers argue that women use abortion extensively as a means of birth control and family planning. However, with better access to effective birth control now available, including healthcare, insurance, and sex education to prevent unwanted pregnancies, there is no need for abortion. The bodily autonomy defense falls short on this point since a woman has complete control over her body to avoid an unwanted pregnancy. This justification for bodily autonomy serves as a cover for reckless sexual practices. Furthermore, to varied degrees, society and the government have always been involved in bodily autonomy. And I will cite a few instances. One, a promiscuous woman pay a moral price in society, and gay activities is illegal in some countries and reprehensible in many cultures and groups. Two, drug use and alcohol abuse are taboo in society and are also against the law. And three, the law requires vaccinations for children. There are many other instances where society and government impose their will on a person's right to bodily autonomy, either by exacting a heavy moral tax or by criminalizing certain behaviors. The second issue at hand that people are fighting about is they're saying that if you ban abortion, then this will effectively kill women. Pro-choicers claim that the law's restriction abortion endanger the health and life of a woman who is seeking treatment for an unviable pregnancy. Pro-life advocates, however, claim that legalizing abortion creates a culture where life is disposable. So who is right? There are a lot of irrelevant arguments put forward in support of this claim. Many women argue that a woman should be allowed to terminate a pregnancy in the event of 1. Rape, 2. Incest, 3. Financial hardship, and 4. Life-threatening pregnancy. These are the main reasons why women are so up in arms about, I should have a right to an abortion. So let us look at these issues that they're putting forward. Less than 5% of abortions occur for the reasons that I just stated, and they are relatively uncommon. The majority of abortions occur for reasons unrelated to the topic at hand. Let us examine each and talk about them. Incest and rape. With the right treatment, pregnancy can be avoided in the cases of incest and rape. Additionally, the circumstances of conception have no relevance to the preservation of life. Therefore, it is reasonable to consider abortion as equally heinous as act of rape and incest. Abortion does not bring healing to the rape victim. Financial hardship. The inability to care for a child is irrelevant to the discussion. According to this logic, it would be fair to assume that the lives of the many people in our society who have financial difficulty and are unable to care for themselves should be terminated as well. This is akin to murder. The argument that women should be permitted to terminate a pregnancy on the grounds of extreme financial challenges must fail because we do not kill people just because they are unable to take care of themselves. The next issue is life-threatening pregnancies. This is arguably the most abused and misunderstood of all pro-abortion claims. Miscarriages and spontaneous abortions are not the same as elective abortions. In cases of spontaneous abortion and miscarriage, the fetus is already dead. So the procedure that the doctor performs to remove the fetus is not an abortion. Furthermore, there have never been any regulations prohibiting a medical professional from acting in the best interest of a pregnant woman. There are no laws preventing women from undergoing medical procedures in the event of an ectopic pregnancy or a septic uterus because those procedures are not considered abortion. And I'd like to pause here to point out something very important. The most contentious and annoying claim that is made by pro-choice advocates is that men should not have an opinion on abortion. Every civilized culture regards the freedom of speech as a fundamental human right. Therefore, it is very disturbing that a group of people advocating for their rights are simultaneously advocating for limits on the rights of another group of people. The abortion debate has become far too polarized. In conclusion, Roe v. Wade demonstrated a judicial failure in the United States. It created a right that did not exist in the US Constitution and then based an entire body of laws on that made up right. Furthermore, much of the debate over personhood is deceptive and riddled with intellectual dishonesty. One would not tell an expectant mother that her unborn child is not a person. Neither would we criticize a woman who has had a miscarriage for the pain that she experienced as a result of that loss. Invoking God and religious dogmas, as well as asserting made-up constitutional rights, are irrelevant to the issue of abortion. However, as a society, we must decide at what point a woman should be allowed to terminate her pregnancy. The choice cannot be left solely up to the woman because the life of another person is involved. There has to be a common ground. And these are my thoughts on the whole abortion debate. So let me know what you think in the comment section down below. Thank you for watching, and I will see you in the next one.